Hi, I'm Andy Roy and this is Nina Ross. We're both barristers at 12 King's Bench Walk Chambers and we both specialise in personal injury. Nina, I'd like to ask you a question about one of the slippery topics in personal injury limitation law, and that's date of knowledge. One of the things a claimant needs to have knowledge of before the limitation period starts to run is that he has sustained a significant injury. What is a significant injury for these purposes?
Well, section 14.1 actually defines what a significant injury is. And that section says, for the purposes of this section, an injury is significant if the person whose date of knowledge is in question would reasonably have considered it sufficiently serious to justify his instituting proceedings for damages against a defendant who does not dispute liability and was able to satisfy a judgment. So that's the statutory definition. How then has that been interpreted by the courts? Well, several key points emerge. And the first is this: the threshold for a significant injury is low. And so most injuries, even relatively trivial ones, generally would qualify as significant. So for example, if an injury were sufficiently serious for a claimant to go and see a doctor, then that would likely qualify as a significant injury. The second key point to bear in mind is that the question of significance is objective. And in the House of Lords case of A. N. Hall, Lord Hoffman said this: the test itself is an entirely impersonal standard, not whether the claimant himself would have considered the injury sufficiently serious to justify proceedings, but whether he reasonably would have done so. So once you've ascertained that what the claimant knew and should have known, then the actual claimant drops out of the picture. And so therefore, if objectively speaking, the injury is significant, then it doesn't matter whether the person didn't necessarily think it was so, and if they were, for example, atypically hysterical and didn't think their injury was worth bothering about, that wouldn't necessarily mean that the injury is insignificant for the purposes of section 14.1.